morning, everyone. I'm Assemblymember Rebecca Bauer-Kahan. I'm the chair of the Privacy and Consumer Protection Committee and the Assemblymember from the 16th Assembly District. And I want to thank you all for being here, both in person and also virtually. I'm so proud this morning to be joined by SAG-AFTRA, the Concept Art Association, the National Association of Voice Actors, and so many others who are fighting for the rights of performers, artists, and creators in the face of rapidly evolving AI technology. As many people have asked my philosophy on AI and the advent of AI and how we should be regulating it, I often say we need to ground ourselves in the values that we've held for as long as we can remember. And copyright is one of those values. There is no question that we as a society decided a long time ago that if someone poured their blood, sweat, and tears into a work of art, a book, a song, a film, that they got to profit off of it. That if one wanted to play it or show it, that you had to pay them for that work. And we did that because artists need to be compensated for their work in order for us to see the incredible art that changes not just our state, but the world. That gives us the opportunity to transport ourselves to another time, another place, to for a moment step into the shoes of another. And so it is with that vision, the continued vision of protecting those works of art that are so central to our state and our communities that we've introduced this piece of legislation, AB 412. And the timing of this press conference couldn't be more poignant, as just last week we heard from both OpenAI and Google that they believe that in order to win the AI race, they need to use copyright material freely and openly. And the question has never been, does someone have the right to use copyrighted material? The question is, do you use it in a way that is compliant with the law and that allows for the artist to profit off of that work? And one of the things about AI and these large language models is that what is in them, in a lot of cases, is a mystery. They put these data sets into the models, and we don't know what went into training them. And then out comes Scarlett Johansson's voice. And so it is critically important that a copyright holder have the right to know if their work went into the training of that model. This bill is incredibly simple. It does just that. Last year, under Assemblymember Irwin's leadership, this body passed and it was signed into law, a law that will allow us to know if a large language model was trained on copyrighted material, yes or no. What this does is it goes a step further. It says that you have a right to know if your copyrighted material was in that large language model. And I think this is incredibly important, and you'll hear from the guests who are with me today, because they have a right to be protected as they create work, as they put it out into the world, and as they want to be paid for it, which I will say they have a right to do. And so California will continue to lead in this area. We will continue to protect the rights of our creators, our copyright owners that fuel the industries that California both enjoys and depends on. So I'm so honored to be fighting for this legislation alongside the incredible advocates here, and I want to thank them for their leadership and for joining with me. And I want to be clear that together we believe this is a fight that is about fairness, transparency, and the future of creative works. And so it's time that we move this bill forward, that we give the transparency that it provides, and that we work together in ensuring that this bill is signed into law this year. With that, I want to turn it over to Jolie Fisher, Secretary-Treasurer of SAG-AFTRA.
Thank you so much. Thank you, Assemblymember Bauer-Kahan, for this important legislation. I am Jolie Fisher, like she said, Secretary-Treasurer of SAG-AFTRA, the union that represents 160,000 individuals who have dedicated their lives to honing their human artistry, perfecting their craft, and drawing on their unique lived experiences to entertain and inform the world. As an actor and as a writer and a member of a multi-generational show business family, I know firsthand that change in my line of work is really the one constant in this industry. From the silver screen to home television, videotapes, remember VHS and Betamax and DVDs, and then on to streaming. And each new technological revolution has disrupted the old way of doing things. The rapid growth of artificial intelligence is only the latest wave of that change. I understand that. And look, my union has no desire to halt technological progress. We do, however, want to make sure that AI improves human lives rather than harming or exploiting us. Here's the simple truth. Everything generated by AI originates from a human creative source. AI can't do anything on its own, and no AI algorithm is able to make something out of nothing. So if intellectual property and copyrighted material is being used to train AI models, the copyright owners need to know. Nothing I'm saying here is particularly radical or controversial. In fact, under our current laws, individuals who distribute copyrighted material for their own financial gain can face up to 5 years in prison and a $250,000 fine. Why then would we allow these big AI companies to mine others' copyrighted works without at least giving the copyright owners a right to know that their work was mined? Just as a potter uses their years of training to make unique, tangible objects, content creators harvest our unique lived experiences to create less tangible but undeniably unique experiences for audiences. For those who make their living creating art and telling stories, our intellectual property rights are everything. It's important to note that this is only one step in protecting humans from AI exploitation. And just as we wouldn't allow anyone to steal a potter's creations and resell those vases and bowls without paying the artisan for their hard work, we shouldn't allow these AI companies to harvest others' intellectual property in the dark. AB 412 is sound, rational legislation. SAG-AFTRA is proud to support this bill. Let's do what needs to be done to get AI Copyright Transparency Act signed into law. Thank you.
Thank you so much, Jolie. And now we're going to turn it over to Carla Ortiz from the Concept Art Association.
Good morning, members of the press. Thank you so much for your time this morning. And thank you in particular to Assembly Member Privacy Committee Chair Rebecca Bauer-Kahan. Thank you for having us this morning and inviting us to speak today. My name is Carla Ortiz. I'm a concept artist, illustrator, and fine artist. I come to you today as a member of the Concept Art Association. You might not know me, but you know my work. My paintings have shaped the worlds of blockbuster Marvel films and TV shows, including Guardians of the Galaxy 3, Loki, Thor Ragnarok, and my art shaped the look of Doctor Strange in the first Doctor Strange movie. Visual artists like myself, we love what we do. We love our craft. We train our whole lives to bring the imaginary to life and make a decent living out of it. Through hard work, support of loved ones, and dedication, I have been able to make a good living from my craft. A craft that thrives when an artist's hard work, intellectual property, and copyrights are respected. Yet this basic respect for our laws is no longer the norm in this new technological age. Generative AI is unlike any other technology that has come before. It is a technology that uniquely exploits the hard work, creativity, and property of others. No other tools are like this. What I found when first researching AI back in 2022 mortified me. I found that almost the entirety of my work, the work of almost every artist I know, and the work of hundreds of thousands of artists globally had been taken without our consent, credit, or compensation. These works were stolen and used to train for-profit technologies with data sets that contain billions of images. But I was lucky that I had found the opportunity to find all these shocking facts back then, before big tech realized that secrecy was the best defense against artists, performers, musicians, and writers whose work their models depend upon, work they do not own. Because of the information that I briefly acquired, I was able to vindicate my rights in the courts via a class action lawsuit that is still ongoing. However, an endless number of my peers are not so lucky. Big tech companies not only took our works without our consent, not only took our works to compete against us in our own markets, they now claim they're entitled to the works we have labored over, to build their billion-dollar industries without us. An outrageous act that under any other context would be clearly seen as unfair, immoral, and illegal. The Concept Art Association and members like myself need transparency, the kind of transparency AB 412 so thoughtfully brings. And we need that transparency now. Because our hard work, our innovations, and our copyrighted works are not their trade secret. Thank you.
Thank you so much, Carla. When I met Carla last year, I think I told her this, but she's inspired many Halloween costumes in my household. So I don't know what our world would be without her art. And now I'm going to turn it over to Tim Freelander from the National Association of Voice Actors.
Thank you. Good morning. It's a pleasure to be here. Thank you to everybody for the invitation. My name is Tim Freelander. I am president and co-founder of the National Association of Voice Actors. I'm joined today by our Vice President, Karen Gilfrey, and our Director of Operations, Matthew Parham. We are pleased to be here to co-sponsor and support AB 412. We represent voice actors across the spectrum and regardless of union affiliation. From those who are working every day on national brands to those who are just beginning their career and just barely making minimum wage. These working-class, blue-collar voice actors are who we represent. Both have equally been damaged by the rise of synthetic voice systems. Over the last 2 years, many NAVA members have found their voices digitally duplicated and used without their consent, control, or compensation, without their consent to know that their voice was in the system, without the control to know what their voice was going to say, and without being compensated for what that voice and usage says in the future. Almost every instance occurred without the knowledge of the voice actor, and the users only discovered this after they heard their voice out in the public on a brand or in a product that they did not approve to be a part of. This includes 2 voice actors who at the debut presentation of an AI company found themselves to be the default brand voice of that company without their approval and without any compensation for the value their copyrighted recordings brought to that company. In order to protect our artist-led small businesses, it is vital to have basic rights to know if a copyrighted piece of our work is used within a data set. This will provide us the ability to preemptively protect our voices before they are used to replace us in the marketplace. We believe that all artists and copyright holders have the right to fairly prosper from the value our creative content provides in this rapidly growing technological environment. And we look forward to working with the tech companies to ensure that we can all continue to thrive in this new AI world. Thank you.
Thank you so much. And then we're going to turn it over to Karen Gilfrey, also from the National Association of Voice Actors.
Good morning. My name is Karen Gilfrey, and I am a voice actor and the Vice President of the National Association of Voice Actors. NAVA is very proud to be a co-sponsor of AB 412, and the reason is this. For decades, artists have been able to control the ownership and use of their creative materials, performances, and artistic works through copyright. But in the new age of generative AI, our copyrighted materials can be used to train and create AI-generated works without legal protections. In fact, Gen AI companies don't even have to inform us when they use our copyrighted materials. The ability to control our copyrighted materials becomes even more important when the materials in question contain our human biometric data, like voice print and visual likeness. As a voice actor, I am particularly concerned about voice print because my voice is the way I make a living and feed my family. Voice print is so individual that when your mom calls you on the phone, you know it's her within a couple of seconds, even if there's no caller ID. And if someone wants to use my voice, that should be my choice. We are approaching the problem of ethical AI use from multiple angles, and the protection of copyrighted materials is one of the important ones. The voice actors and the production partners, movie studios, game developers, and other creative partners we work with all need a mechanism to defend their intellectual property, and AB 412 would give them that mechanism. Thank you.
Thank you so much to everyone today, and I hope that what we heard today really hits home the point of why this work is so important. And as we all know, copyright mostly sits within federal law, but this is something California can do. We can do transparency, and we can give these Californians the right to know when their work, their voice, their image, their art is being used in the world, and that is really, really an important step forward as we move to a world where AI is so rapidly developing. And so we have the opportunity to lead the nation to set a different example, one that allows for the innovation of AI to happen but protects artists, actors, and voices who power a creative economy and who make what I like to believe is a little bit of magic in our world. So I appreciate you all for being here today, and I'm happy to take any questions if anyone has any. I know Tyler said he was coming prepared. Yes.
Industry opponents of the bill have said that this could undermine fair use and have said that they're not taking copyrighted material, that their AI models are simply studying off it the way any student would, creating their own work based off of what it learns. Is that accurate in your opinion?
So fair use, this doesn't change fair use law, as I'm sure you're aware. If the courts, which so far they have not deemed it to be fair use, so I guess I would defer to the judicial branch to say, and Congress, who could affect whether or not this is fair use, whether this is fair use, the question then becomes, how do you even know if it's being used? These models are so large, so much data is being put into them, that the question we're trying to answer here is that my voice? Is that my work? Is that my art? And so, what the courts and what the federal government will decide about fair use is a separate question from whether we believe these copyright holders have a right to know what is going into the data sets. Yeah.
Some advocates have said that they wanted to, in future edits of this bill, put in kind of a deletion mechanism where one will request them to delete their copyrighted work in that training data set. I'm just curious if, one, you see me support the idea, and two, if you think that's feasible or too ambitious or whatever.
So that's a real question, a technical question. Is it possible, once data sets train a large language model, to delete a piece of that model without deleting the entire model? And my understanding is right now you'd have to start training the model all over again with a new data set. There are obviously huge implications to that, although, if the federal courts were to find this isn't fair use and it was in the data sets, the question of how that would be handled is one that would have to be resolved and would obviously deal with this technical issue. But I will say we've been working with incredible academics who specialize in AI and specialize in protecting copyrighted works, who've been using technology to do that. And so we are talking to the best of the best to decide how to do this. The amendments that are coming out today in the Privacy and Consumer Protection hearing rely on that, help us understand how do we technically make this possible. There were some changes in the language that rely on the way currently data sets are analyzed, and adding in copyright is another piece of how these should be analyzed. So we'll continue to look at how we can best protect these artists, but we think this is a huge step forward.
And why did you take those amendments?
Well, I believe that every bill that comes through my committee, whether it's mine or someone else's, needs to be in the best shape possible. And one of the questions leading up to this committee hearing was, there is no repository of every copyrighted work that would allow the data sets to be analyzed. And so how are they going to do this? Which is a real question. We shouldn't be doing policy that isn't possible. And so the change that was made, the biggest change that was made, really uses as a model the way we analyze data sets for child sexual assault material, abuse material, which is that hashing mechanism which is now in the bill. So this would allow copyright holders to create hashes of their works, which then would be compared against the data set. So technically now it is possible to know whether their copyrighted work is in there. Yeah.
Regarding the governor's AI working group, they put out a report this morning with some of their recommendations themselves on AI policy. Do you feel like AB 412 aligns with those recommendations?
You know, I've been briefed on it yesterday, but as you said, it is hot off the press, so I would like to spend more time before I fully weigh in on the report. But I will start by saying that I know that the crux of the report is really how does California continue to lead in protecting against the harms of AI while balancing innovation. And I actually think the amendments that are coming out today with that hashing is a perfect example of that. We're leaning to how the technology companies already do business. And we think that in so doing, we're not adding much burden, but protecting what is a fundamental right.
Do you have any reaction to the report more generally? You said it is hot off the presses.
Yeah, so give me 24 hours, Tyler, and we'll get back to you on that. Awesome. Well, thank you all for being here. And the hearing is this afternoon if you want to see what happens later. But I look forward to it. Thank you.